And welcome. This is Justice Serve TV. Michael Bryant here, and Domino's there working hard as usual. Hey, what is the latest in the YNW Melly case? What's happening with YSL? Is that still a thing? Is it still around? Well, luckily we have our special correspondent in Georgia, Doug Weinstein. He's going to join us. We've got all kinds of details and all kinds of stuff. Stay right where you are.
Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down, I lead the way. Hoping justice will win the day. It's Nary Clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
All righty, then. We got so much going on here. Of course, Linda Kenny Baden, she is on assignment. She checked in earlier. She's wrapping up her duties at Harvard, and actually will be back on Monday. That's my understanding. So let's get into stuff. Okay, before I bring Doug on here, a couple of quickies. We've been following the Uvalde case, obviously, out of Texas, the case against the police officer, former officer, who has now been charged 29 counts of child endangering. That trial is continuing today. Some gruesome stuff, most of which we were not seeing. Only the jury did. They will not release this stuff. They were not autopsy photos. They were crime scene photos, basically detailing where the children were killed. Just brutal. I think this leads to a lot of potential appellate issues, because the question becomes, if all we're talking about here is the guilt of the officer who, in the prosecution's opinion, did not act fast enough, did not do the right thing at the right time to protect those children, how much do we need to see about the aftermath? You know, I know you have to get into the danger, but it's a very difficult balance there. And I guarantee if there's a conviction, 29 counts carries a total of potentially 58 years in jail, not prison there. These are going to be issues that the jury was exposed to way too many things that evoked their sympathy. They held it against this guy because the shooter is dead, right? Okay, in the Kelsey Fitzsimmons case, remember the grandparents, that's Lauren Page, Kelsey's mom, Will Page, her stepdad, had filed for visitation of the little boy a month or so ago. The last time we chatted, it was kind of up in the air. Well, today they have announced from the family court a hearing on that issue. Sit and wait for a while. August 7th. That's when it's going to happen. I've reached out to Will to get a reaction from him. I understand that is not unusual in the family and probate court there in Essex County. So, yes, it's good news. It's on the calendar. The baby will be, at that point, almost a year and a half old. Anyway, so, finally, one more thing on the Michael Bryant versus Massachusetts State Police front. You recall at the end of December, we had asked the court for leave to amend and file a second amended complaint against the Troopas, specifically Troopa Hodman. That has been granted, and so the second amended complaint has now been filed. The Massachusetts State Police and all defendants have 14 days now to respond, so obviously we will get into that when that document appears. But right now, tonight, there's so many things that have been going on in the Southland, and when that happens, we have no better person to check with than this guy right here. Doug Weinstein, how are you, sir? It's good to see you.
I'm doing great, Michael. How are you? It's always good to be
well.
on, and thank you for inviting me. It's a privilege and a pleasure.
We agree completely. It's good to have you. And so, first thing I think about is the timing on this is interesting. Your former colleague, I guess you're still a colleague, Bryant
Sure.
Field, represented Jeffrey Williams in the case in which you got an acquittal for Diamante Kendrick, your client, in the massive YSL. It seems like so long ago. And I guess in a way it has been, but it's still haunting us. Jeffrey Williams had all this property taken. And as folks have learned through us and other sources, that, once that happens, you have to basically say, hey, after the fact, can I have my stuff back? Can I have my stuff? So I guess he got some of his jewelry back maybe last year. I think it might have been February of last year. But there's still the list I have. Where's my list? there was a number of things on here. Just money, right? Money is one thing. 145 grand in cash. He had some firearms, a Glock, a couple of Glocks. He had a Smith & Wesson, a couple more Glocks, Chevy Corvette, Jeep Grand Cherokee, Dodge Durango, Can-Am Spyder. Well, apparently the court, and I want to get into this because I think you're a fan of Judge Paige Whitaker. I am. She was faced with dealing with, the county's objection to giving up this material, right? So
Right, this is right.
It's now been turned over. He has it.
Finally. I think that's the right way to put it. And I don't know how much you want me to go into this. Obviously, what happened was they seized all of his goods. I guess it would have been May of 22, years ago, or maybe it was May of 23. It's been such a long case; it's hard for me to get the years right. And they filed a civil forfeiture action to take those goods. And what generally happens, at least what we tend to do in Georgia, not always, is we stay that civil forfeiture case until the criminal case is resolved. Because obviously you don't want your clients testifying in a civil forfeiture case when that testimony in subject to cross-examination and everything else. So civil forfeiture case is stayed. Once the criminal case is resolved, it moves forward. I won't go into all the details, but last summer, basically, the Fulton County DA's office fumbled the ball on some filings, and Brian Steele was essentially able to get the civil forfeiture case dismissed with a ruling in favor of Jeffrey Williams, of Young Thug. Paige Whitaker said, "Give him his stuff back." And as you probably know, the Fulton County DA's office can be tenacious, so they filed basically an appeal. However, in the hearing last summer, there's no court reporter provided standard in that type of a civil hearing. So Brian Steele reached out to the DA's office. Hey, do you want to split the cost of a court reporter? The DA's office is like, no, we're good. We don't think we'll need one. Of course, then the DA's office loses. They reach out to Brian Steele because you need a copy of that transcript for the appeal. Brian Steele, being the consummate gentleman and professional that he is, said, okay, here's the court reporter information. The Fulton County had 30 days to get that transcript and file it. After 30 days, they didn't have the transcript, so they filed a motion with the court. Hey, the court reporting service isn't able to get the transcript in time. Can you please give us another 30 days? Implying, and maybe directly saying, that they've reached out to the court reporter service. So Judge Whitaker gives them the 30 days. Once again, they don't get the transcript. So they ask for another 30-day extension, again, saying that they've reached out to the court reporting service and it's not ready. Judge Paige Whitaker, in her infinite patience, which somehow she still manages, gives them the other 30 days, and they still do not have the transcript. So now the question is this, do you just dismiss this appeal at this point because they have not filed the transcript that's required? So the hearing this week was on that issue. And the Judge Whitaker came out with an order that said, your delay in filing this transcript was inexcusable. And she didn't mean that in a scolding way. That's a standard under the law. So that was an inexcusable delay. And by the way, you lied about having reached out to the court reporting service. Now, how does Judge Whitaker, cut me off if you want, but how does Judge Whitaker know that they're lying? Because Brian Steele is always prepared to the nth degree. And he'd reached out to the court reporting service and talked to them. And they said, no one from the DA's office has reached out to us. In the hearing this week, Brian had them prepared to testify from the court reporting service. And at that point, the DA's office admitted, we didn't really reach out to the DA's office. So in the order this week, Judge Whitaker, in a very judicious and measured tone, had found that basically they had lied to the court about reaching out to the office and said, hey, Madam DA Fonnie Willis, you have until Friday at 5 p.m. to return all of this stuff that I ordered you to return last summer.
And Fonny was smacked in the fanny, and so they did it yesterday. Actually beat the deadline. I'm kind of surprised.
They stunningly, surprisingly, yeah. My understanding is it was all returned by 5 yesterday. And I think, and I can't tell for sure because I haven't dedicated enough time to it, but I think Jeffrey Williams, young thug, maybe put a clip out there of him wearing some of his jewelry, but I'm not quite sure about that part. Now,
everybody's most concerned about the missing Richard Mille watch, which,
yeah,
if it surfaced, I'm guessing would have been part of the salvo from last February that he was given his jewelry, because the list I see for the stuff most recently turned over, there was no jewelry in that. Is that true or not?
I think he did get some jewelry back in this. A lot of the jewelry that had previously, this is a whole nother side story in YSL in Judge Glanville, but a good amount of the jewelry that had been seized at Jeff's house was actually basically on consignment to him, not consignment, but on loan to him from the jewelry store. So the jewelry store had hired, oh, don't make me blank on his name, had hired Manny Aurora to try to get their jewelry back, because it wasn't Young Thug's jewelry. It was this jewelry store.
So is he like a PI or something, or what is he? What is he?
No, Manny Aurora is an amazing criminal defense attorney down here.
Oh, he's an attorney. Okay.
He's an attorney. He just had a big victory in Memphis a few months ago on a fairly well-known, I want to say, a rapper case there. But Manny went to Judge Glanville multiple times, filing motions and everything else, seeking to have the jewelry returned. And when I wrote in YSL that Judge Glanville's courtrooms is where writs go to die, the footnote that had been dropped into there were the multiple writs that Manny Aurora had filed on behalf of this jewelry store, trying to get the jewelry back. So a lot of that jewelry returned last February was jewelry that wasn't actually owned by Jeffrey Williams, but had been lent to him by, and I don't know if it was Icebox, I can't remember the jewelry store, by the jewelry store. So yeah, so right now, in theory, Fulton County should be in possession of none of Jeffrey Williams' property.
That's the theory. So let me ask you a little bit about just the practical aspect of this. First of all, for folks who may not understand the whole confiscation process, if in fact it's not his stuff, then they have no right to it, and that's why the jewelry store had to repeatedly, try to make that point to get their stuff back. And stars like Jeffrey Williams, Diamante Kendrick, sometimes jewelers love to drape their stuff on those folks for publicity. We see it at award shows, and back in my days with Extra, you see the red carpet and people have a lot of bling that quite often that they don't own. So it was ridiculous that the attorney hired specifically for that, which I'm sure he didn't work for free for the jewelry store. They had to, they're out of pocket to get their own stuff. And did Glanville finally do the right thing, or did it get past him until Judge Whitaker took over?
I believe it wasn't acted on until Judge Whitaker took over, but I am not sure about that. I do know that when I had filed my petition to the Supreme Court and I mentioned that, Judge Glanville's chambers reached out to me and asked to receive copies of those writs that they hadn't acted on. And they were given copies of those writs, but there was certainly no action taken during the entire course of the YSL trial. And that jeweler was out. The numbers were huge as to what that jewelry was worth. It's got to be well over $1 million worth of jewelry that the jewelry store was missing out on. So, and as far as the logistics, it's turned over to either, when it's returned to Jeffrey Williams, it's returned either to him personally or his representative, who would have power of attorney to get the goods. People were asked, was it like stacks of cash that were returned? I would imagine it's a check, because when you seize money, it's supposed to be put in an interest-bearing account. And since, so as to the Richard Mille watch, since that was not in the inventory, I would imagine that he has not gotten that watch back, because they contend they didn't have it.
Right. And weren't there two and he got one, or did I misread that?
There were two Richard Mille watches that were in that closet for the hardcore YSL watchers that saw the videotape I played over and over again.
I remember, and that one had like a white band, I think, but the other one was distinctly different looking, but it's vanished and nobody ever really saw it or could track it.
The last
that-
person whose hands were on it were Detective Viverito was the last one I saw.
Ah,
And when
Viverito.
Yeah. And when I had her on the stand, she basically implied that Big Jeff, Jeffrey Williams' father, must have stolen it.
Ah, of course.
Right.
Yeah. How is the Detective Viverito? Is she doing okay? Has she?
I have
raised-
not seen her since I had the pleasure of taking Kenneth Copeland to a Hawks game last December and about 13 months ago. And I saw her because she runs, at the time at least, she ran security for the Hawks. So I've got Tasha.
She was there.
Yeah, she was
So she
there.
was there? That's so funny.
She was there.
Yeah, well, she is undercover. I mean, people were laughing because she wanted to hide her identity, but had a IMDb, Facebook presence that made it. She had gotten some award of some sort recently. So she's plastered everywhere, but didn't want to be shown during the.
Yeah, I don't know why you spend all that money on plastic surgery and then don't want to show it off.
Yeah,
That's
good question. Maybe it wasn't her good side, and she was concerned. It might not be the good side. Okay, so are there any other shrapnel from the YSL case that's still out there? Anything you're aware of?
That's a good question. I believe everything in that case is fully resolved. There were 4 defendants remaining to be tried at the end of YSL, and those all resolved this past spring. I think with pleas.
Yeah, I do remember those kind of falling pretty quickly, one after the other, with some sort of deal. Yeah. Okay, well, let's talk about Fani for just a minute, because she had a day in front of the Senate committee, the state Senate committee, or some level of state government that was really just exploring the whole money issue and the Nathan Wade issue. And she lived up to her billing. I ran it here one day. She is the gift that keeps on giving. That attitude, that arrogance, it's unbelievable to me. But it appears
some people may call it arrogance, and some people may call it confidence. It's a little different to me than when she took the witness stand in court, right? That's a serious legal issue. You're at a hearing. There's a major trial involved. I think there's a certain level of respect and honesty that's required in the court that may not be required in what is almost not 100%, but 80% a political show that the Georgia legislature is putting on. And yes, there is a basis for their inquiry, but that's like a political hearing like you'll have on Capitol Hill sometimes. So, but still, is that the way I would have approached it if I were her, or if I were counseling her? Of course not. showing up in that, what was it, like a white coat thing?
It looked like some sort of gala. She made the entrance there with.
And I don't know if people saw this or we're just boring all your viewers, but she was represented by the very well respected by all political parties, former governor of Georgia, Roy Barnes, who's a phenomenal lawyer. And I kind of felt it's his choice, whether to take it on or not. But I felt for him to some degree. And he did his best to protect his client and do a little battle himself with the senators there at that hearing. But one of the things I think people should have taken from that hearing is she really made a full-throated attack on the Superior Court judges within Fulton County. She really did. And one of the underlying tensions that I know that everybody is following is there is a bit of a scuffle, tensions between the Fulton County DA's office and the judges on the Superior Court of Fulton County. And you see some of that with Judge Whitaker in YSL. You see it in Fani Willis she's directly attacked Judge Whitaker. She's attacked McBurney. She's attacked McAfee. And I don't know if you saw, but McBurney clapped back last week. Judge McBurney did on Fani Willis, where and I can tell you this, or we can drop it and talk about it later. But Adam
Go ahead.
Abate, who's a high level, like a chief ADA within Fulton County, and an excellent prosecutor, and one of the ones that really came in the last month of YSL. Adam was in front of Judge McBurney, who streams all of his court proceedings on YouTube, which I applaud and think everyone should do that. He streams all of his court proceedings on YouTube, and McBurney made a remark to Adam Abate just casually about bonuses being given out in December to the prosecutors. And he asked if Judge McBurney asked Adam Abate if he got that bonus in cash, because he understands that the DA's office keeps likes to deal in cash a lot.
A lot of slush. Yeah. A lot of slush fund there. So, somebody mentioned this, and maybe you can mention, because people may remember took a deal early in the process, and ultimately is probably doing more time than anybody else.
Yeah, and happily angry lawyer who just posted on there is fighting the good fight to try to help Mung Tuk out in this situation. And I have not followed that. I'm embarrassed to admit this with happily angry sitting here looking. I have not followed that the way I should have, but he's doing the good fight for Mung Tuk, and I applaud what he is doing and everyone that is supporting Mung Tuk, because yeah, he got revoked. Judge Whitaker did not take kindly to my social media comments regarding that revocation. Because I think that I made a social media comment that Mung Tuk had been revoked just for getting on the stand and telling the truth. And I know for a fact that she was not pleased with my saying that. So I think Happily Angry is going to step in and try to fix all of this. There's a lot of errors in several things relating to Mung Tuk.
Yeah, and some folks, Nikki 8, is that Nikki B? Nikki B 316, curious to know if there's a GoFundMe for Mung Tuk. So anybody knows, pass that along. Yeah, I mean that was really one of the tragedies of the whole trial as it ended. When he did his deal, regardless of the revocation, it was so early on, and there were so many unknowns, and nobody could really blame him for doing what he did at the time. But as we look at it in retrospect, it's like, too bad.
And his lawyer, who was representing him under that initial plea deal, I think unfairly caught some grief on the internet and other places. And I think what people see as Happily Angry lawyer digs into this is that he really should not have caught as much of that blame. And there were just a slew of errors committed by the state and arguably some judges in that situation.
So how is Judge Whitaker was all over this, obviously the end of the Jeffrey Williams property. People talked about her heading on to, higher benches. What's the word there? Have you heard anything?
She is shortlisted. I say is because I don't know the current status, but I don't believe a selection has been made. She was one of 4 shortlisted to the Court of Appeals. There was an opening on the Georgia Supreme Court. It was filled with a lawyer off the Court of Appeals, a judge off the Court of Appeals. So now that Court of Appeals position is open. All 4 candidates are highly qualified for that. There's 2 judges that I really, really like that are up for that, Judge Whitaker and a judge in Cobb County who I have great respect for, Rob Leonard. I'd love to see either of them get that appellate position, but of course, I'm rooting for Judge Whitaker to get it. Although it would be a tremendous loss to trial attorneys in Fulton County to lose. But she deserves. If she wants that, she deserves it, and she should get it.
Yeah, and that seems to be the way it works. Good judges at the trial level are elevated, and then there's unfortunately a loss at the trial level. Is that Supreme Court picks them? How does the selection process work there?
To when there's a vacancy at the Superior Court.
Yeah.
Oh, to the appellate court, the governor picks all vacancies. Supreme Court, appellate court, and the Superior Court, and then when it's their turn, if they choose, they can run for a re-election at that point in time.
Gotcha. Okay.
Which is usually kind of a gimme, but not always.
And so are there vacancies now in the appellate court, or is it a list for when vacancies arise?
No, there's one vacancy right now because a judge
Okay.
was plucked off the appellate court to go on to the Georgia Supreme Court. So we have a vacancy on the appellate court. And I know I was speaking to one of the judges that was up for that position in early December, late November, and he was about to be interviewed by the governor and I guess some others, even though he'd already been shortlisted. I assume that process completed before Christmas, but I don't know if the governor's made his selection yet.
All right. So do what you can do there in that process.
Yeah.
You know, make some calls. Before I forget, hey, folks, like, share, do all those other things you're supposed to do. So let's talk now. YNW Melly.
I'm going to pull up my notes before you do that.
Yeah, pull up your notes. I mean,
I've got my notes up. Okay, I'm ready to go.
This is another one of those cases. I remember we covered the original trial. I think it was in 23, back when I was at Law and Crime. Does that sound right? This is the case in which he's accused in the deaths of two associates. Yeah, there you go. Colleagues, associates. The defense was it was a drive-by and the jury was hung. So now they're plotting very slowly, sloth-like, toward the next trial, which is set for January next year.
Right.
And in the meantime, we have witness intimidation trial. And that, I just heard, I think Kat Not Williams was talking about this, and I snagged this from her. Thanks, Kat Not Williams. They were going to have a hearing Monday to continue some of the preliminary information or motions in limine for the witness intimidation trial. That has now been pushed by mutual agreement, but only till later in the week. I think the 19th is the trial date at this point.
I think it's January 21st, but I may have that wrong.
Is it 21st? Okay, no, 19th is a Monday, so I just went to that date. But it's coming up, and it sounds like it's going to happen. What, if you can recall, as I remember, it was Cortland Henry, and I call him that because I'm not a member of the Bloods, so I would call him Bortland. His girlfriend was intimidated allegedly by YNW Melly. Is that the
allegedly there was a note passed from YNW Melly through several other prisoners, eventually resulting in a phone call. That's the allegation of witness tampering. And so, and I think you've said this. I just want to make sure everyone understands there are two different trials here that Melly is facing, right? He's got the witness tampering one on what I think is the 21st, whatever. At the end of this month, he has the witness tampering trial, and then the murder trial, which is 1 year from now.
Yes, and if I did make that clear, that is very important. And this is, and they agreed to do this, and it makes perfect sense. Why jumble all of that mess together?
No.
And there were all kinds of conflict of interest issues, which is why the current double murder trial has been pushed out so far. There have been some, let's just say, some attorney swaps here and there as a result of conflicts. And you know, anytime that happens, you're gonna have to push because the new counsel.
The judge heard a bunch of motions this week on the tampering trial, which is kind of what I was looking back through. And
I've got there were lots of stuff. There was a lot.
Yeah, a lot of them. He hasn't ruled on most of them, but there were a lot of motions that were filed this week. That I think the defense should win some of them, but of course I do. You know, that's the side of the table.
Well, I do too. I mean, they're talking about statements that really don't seem to have any relevance to the witness intimidation. They may be relevant to the double murder, but not the witness intimidation. So yeah, I was going through those today, and I'm looking through them to highlight those that I thought were appropriate in terms of the trial that is pending. I only found the one, which was the phone call between Cortland Henry, and I noticed, you know, for those who, I got an education in this back in 2023, the whole Bloods, Crips changing the initial of the first name.
The BC thing.
Yeah. So in the paperwork, they do call him Cortland Henry, which I got in the habit of calling him. And people are, what do you mean? Is he related to Bortland Henry? Same person. Yeah. But that's all I saw was the phone call between him and Genevia. Is that how you pronounce that?
I think
Genevia?
so. I think so. I can't swear to that.
Yeah, that's the girlfriend, and that's the one that suggested maybe it'd be better. Let me see if they phrased it. And you know, I don't think they had a quote, there was a suggestion here. The message allegedly intended to encourage her to withhold testimony, evade legal process, or be absent from the trial.
Yeah.
So, and that's all it says. It doesn't get into how that encouragement played out, if it did. So
No, but just the act of reaching out is arguably tampering. You don't even.
I think, isn't it true too? And of course, we've gotten an education on witness intimidation through the Aiden Carney matter and the mess up in Massachusetts with Karen Reed and those corollaries. In every location, witness intimidation might be very different. Up there, it's I hurt your feelings, therefore I've intimidated you. But in this case, you got to look at the players, right? You've got to look at these folks that they have a certain attitude. They have a certain persona. They have a certain reputation. So maybe they don't have to do as much as, you or I, Doug, might have to do if we were trying to intimidate somebody. It might need to be more obvious.
I think if that's exactly right. No, but it is, they look at all the circumstances and not just that particular message or action, but they look at it in context. So at least in Florida. So that's what they're doing. But this is, I was disappointed, at least in that one ruling of the judge where they tried to keep from the tampering jury that he has these murder charges against him. And the defense, I don't know if you read that particular motion, but the defense tried to keep that out. And that's one of the few things the judge did rule on. And the judge said, no, that can come in.
That's a tough call, don't you think? Don't you? Because obviously, to me, it's very prejudicial. The theory is, well, if you know what the underlying charge is, it makes it more likely that intimidation was the goal. If it's a jaywalking, is somebody going to intimidate a witness about a jaywalking charge? So I get that, but I just think at a certain point it becomes too prejudicial.
Yeah, but I guess there are you can show some motive, and you can show why any little remarks might carry some weight given the underlying charges. This is someone accused of doing this, killing someone or having them killed, and so therefore, when they suggest you may want to absent yourself, that might carry more weight than if I suggest that somebody should absent themselves. Not that I haven't killed someone, but I'm just saying I've not been accused of killing someone.
That's my take, that it's that it has to be looked at as part of the totality of circumstances. In a vacuum, it would mean much different. So let's talk about the practical effect. The guy's facing a double murder charge. He's in custody.
Yeah.
Is this a pimple? I mean, witness intimidation, if he's even found guilty, assuming that he's then found guilty of murder. I mean, it's, Well,
one of the things I was wondering about is if he is found guilty of the witness intimidation, now does that come in under 404B or other exceptions? Now you bring this into the murder trial, right? As one of the pieces of evidence that the state can introduce to show consciousness of guilt. I mean, who knows what else they could use it for? But there's so many exceptions to in these laws on 404B and everything else that you could see them wanting this conviction in order to bring that into the murder trial.
Yep, I could see that, and I would do the same thing. I would want to use it. It's
certainly.
Why else would you try to intimidate a witness if you're innocent? Maybe because that testimony is going to unfairly prejudice you in that trial, even though you're innocent. So of course you don't want them to testify, even if it's a lie. So, but I think that's a tough sell. I think people are going to just reasonably think, intimidated a witness? Why would he want to do that? I wonder, and maybe why the jury specifically got hung on the first trial. Do you have any real feedback on that?
I do not
read a lot about that.
I haven't, and maybe this has happened, and some of your viewers could chime in on this if they've seen it. But I don't know that I've even seen interviews with jurors where they opined where they talked about why they ended up hanging. I don't know what the split was. I know they were given an Allen charge prior to hanging, and they still hung. Although I think they didn't even deliberate that long. I want to say they deliberated about 13 hours 16 hours, something in that range. Which, I mean, I just had a murder trial at the end of November, where the entire trial substantively took 1 day and 1 morning, and the jurors deliberated for 2 days. They deliberated longer than what the trial was. So to me, I don't understand how you hang after 13, 14, 15 hours. I think you should probably keep working a little more. But again, I don't know the details. And so, yeah, they did hang.
Yeah. Dizzy's saying
14 hours deliberation.
So
yeah, it just seems
that's pretty good
a lot.
recollection. Obviously, as I recall, it was limited number of charges. It wasn't like they had a big pile to go through.
Did you see the motion that was argued or this week regarding lyrics? Because that's my hobby horse, right?
That always got me so annoyed. It just to take that form of art, especially when the goal of those creating that art is a certain persona and a certain personality and a reputation, to exaggerate. It just seems so ridiculous to be able to introduce that as some sort of evidence that you acted consistent with your lyrics. So tell us, well, I know that wasn't there a change to the statute there in Georgia?
In Georgia, no.
No,
we have not.
Was it in Florida? Where was it? Where was the change?
California changed. New York has a change. Several of the states do. I don't know if Florida did or not. We really need it on a national level. But anyway, I think we're going to have to go state by state on all the state crimes. So in this case, the prosecutor is trying to introduce not only his lyrics, but music videos. And all of these talk about predating the alleged crime. This is stuff that was the teens, right? 2017, 2016, 2018. They're trying to introduce those lyrics in video, and how they can possibly have any probative value. Forget more prejudicial than probative. I don't know, because as the defense argued, it wasn't contemporaneous with the tampering. It's pure artistic expression. It's not if you listen to the lyrics or see the lyrics, they're not confessing to anything, because obviously they can't, because it's years before. They don't show action in conformity. Like where he had intimidated witnesses in a lyric. To me, it's just, again, another example of the state using lyrics from, again, only people of color against them in these kind of trials, just to dirty up people in front of the jury. And why the judge even has to consider this, I don't know, because I think the state's arguments are terrible.
Yeah, to me, it's just common sense. Prior bad acts, which this is sort of encompasses that in the broadest sense, are generally not going to be allowed. And this is 3 levels removed from a true prior bad act. So
it's a lyric.
I don't get it. I don't get it. Yeah,
it's a lyric. I mean, you could have a whole show on me just bitching about lyrics, but I'm not an absolutist on this. If you are involved in a homicide and then you immediately go into a studio and start laying down lyrics that clearly are describing, or basically a confession, I get it when that comes in. It makes perfect sense.
Sure. If it's corroborative, if it's just not in a vacuum, a story about murder or trials or whatever, shooting somebody. Yeah. But if it corroborates, that's a very different thing. So, and that's up to the judges to, use their brilliance to walk that line. And sometimes, but
everyone watching, lobby your state legislators to pass, and your congresspeople in Washington to pass the RAP Act, which will still allow these things in when it's appropriate, but keep it out in cases like this where it's unrelated. So the judge, you don't even have a situation where a judge will make that call. If they're following the law, they'll keep out lyrics in just this type of situation.
So do those laws, as you know them, I know they're different here and there, do they create a presumption that it's out, and therefore you have to overcome that presumption to get it in?
Essentially, that's what they do. And you have to the prosecution has to make a certain showing, which is, not an unreasonable showing to have to make prior to introducing those lyrics. So it's a bit of a burden shifting.
Yeah,
law.
exactly. Exactly. Okay, I want to ask you about another case, a little bit unfair because I didn't warn you about this, but it's the Uvalde
Totally
case
unfair.
we're talking about. Totally unfair. So you feel free to object. But this is such a defense struggle. This case, have this Uvalde case, 19 children killed, 2 teachers, the worst school shooting in Texas history, and then you have this defense team, very interesting defense team, I think. And the 2 biggest hurdles, in my opinion, and this is what I want to get your take on, is the overwhelming sympathy that everybody is going to have for the parents in the room, for the children that are gone, the shooter's dead, so who do we go after? We got this cop. And the charges are child endangerment or child endangering. The court has so many fine line decisions to make about how much evidence is coming in, how many of those pictures, today they did a lot of stuff on bullets, where they found them, where the damage from bullets were, where the casings were. Now, if I'm the prosecution, I'm constantly going to be arguing, well, that all relates to where this defendant, the cop who first showed up on the scene, Adrian Gonzalez, where he was at various times and what he could see and what he knew and what opportunity he had to do more than he did. But if I'm on the defense, I'm just saying, why do we need to see photos of the classroom with the children's bodies? Now they didn't show those to anybody but the jurors, but that's all that matters.
Yeah.
How do you fight that? How do you deal with that? I mean, other than start making notes about your appellate issues.
I mean, that's exactly what it is. It's. I think first of all, and I'm sure they did this. I mean, if you have a judge,
sure, yeah.
If you have a judge that right, a motion in limine, and if you have a judge though that cares about their reputation and doesn't want to be overturned on appeal, you kind of let them know that they may be facing that. Now, some judges, I mean, you saw a judge in one of my cases that in these situations he would just very flippantly say, "If I'm wrong, the Court of Appeals will tell me so," and that was the attitude. But I think a lot of judges.
The Casotis case?
No, it's a different case. But Casotis case, Judge Rose was fantastic in the Casotis case. Shout out to Judge Rose. But to me, when I'm hearing you at the opening of the show, talk about what the prosecution was able to show the jury, a couple of things went through my head. One is, to me, it's obviously more prejudicial than probative. I mean, I don't think it's even a close case. And ripe for appeal. And is this a situation where you have a prosecution team that cares more about the conviction than about getting a conviction that can be supported on appeal? I deal with a number of prosecutors who are very careful in their cases because if they win, they want their case to survive an appeal. So they're not going, they're going to push the line, obviously, but not to the extent where they feel like they could lose the case on appeal. And so why the prosecutors want to get this in, how the judge could let this in, I don't think showing those tremendous number of photographs in any way can be relevant to the jury's decision as to the actions of this officer, this defendant. And you're right, the poor defense, I would say poor defense team. The defense team is not only dealing with, you mentioned sympathy, but if you remember at the time and in the weeks that followed, the outrage, not just in that community, but nationally at the officers who arguably did not do their job or the officer that did not respond. Because this is not the first time you've had a situation with an officer that shows up on scene and then doesn't respond the way he has been trained to respond. So I think the combination of sympathy and outrage is going to be very difficult. And so when you have that, I think the judge should be even more careful in making that 403 balancing test, which I think he, just based on what I heard from you today, I think he
don't count on me.
He or she messed up. He or she messed this one up.
Yeah, and certainly he did limit many things, autopsy photos, but to me, If everything the prosecution puts in is designed to lead toward guilt on the part of this very specific individual, you've got to finally tailor that. And the only argument I could make to use some of that is the charges are child endangerment. The jury needs to see what the ultimate danger was that he failed to prevent.
Yeah, I would agree with that.
That's as good as I can get. And I just think at a certain point, it's too much.
Yeah, to show images that are almost purely there in reality and just, get the prosecutor over a beer sometime. They're just there to really inflame the jury. It's just not right. It's not the right call. And so I'm glad the judge clearly, or maybe between the prosecution and the defense, they've come to agreements on things like autopsy photos. But on this one, I think they're wrong. You mentioned autopsy photos in Georgia. I can't keep them out, but usually I can reach agreement with the prosecutor to limit the number of them, to not go wild on some of these things.
Yeah, I mean, and to your point, they're not helping themselves, because that's the kind of thing on appeal that could come back to bite them in the ass if it's so cumulative and overwhelming that it is prejudicial. So you're kind of helping them, and it really the prosecutor should be smart enough to understand that too.
Yeah, so. I mean, when we lose emotion like that, on keeping this out that came in today, that's when I kind of turn to my client and say, well, that's an issue for appeal. We've got that in our back pocket. The problem is, I don't know what the standard is in Texas. In Georgia, it's really winning an appeal can be very difficult because the standard is so high.
Yeah. One other thing I thought was an issue. Tell me how you would deal with this if you can. This guy is now the focus. Adrian Gonzalez is the focus of all of that amnesty that you talked about. Everybody hates this guy. Now, the police chief is going to be tried soon after. I don't know. I think in the next few months. What's Arredondo, I think his name is. The police chief of 6 officers, very small department there. I would think he should have been tried first. But I mean, he's in a position of control, authority, and so. But somehow they're trying this guy first, who was called to the scene because of a car crash, because the shooter's truck was used to ram into the ditch and get him to the school. He just seems to me to be more tangential, but just my opinion. So the other thing that I think the defense has to really work hard on is that time period. We have seen, and I'm curious to see how much of this video is allowed in, shot after shot of attorneys. That's a Freudian slip. Of police officers not doing their job and just kind of hanging out in the hallway, right? While things are happening. And guys, everybody remembers the cop that went over and used the hand sanitizer that was hanging on the hall, wall. Yeah. So to me, there's this spectrum in time that certain people will decide that's too much. 10 minutes before he did anything, 15 minutes, 20. When you get to 74, 5, 6, 7 minutes, I think most people in a vacuum would say that's just too much. That's too much. How do you work with that, counsel? How do you fix that?
And by the way, can't you see the prosecutor in their closing setting up a timer, a stopwatch, a big display that runs, and then every, there's a shot. Now we're 5 minutes. Now we're 7 minutes. Now we're 10 minutes. And just more shots,
Agonizing.
And letting the jury experience that delay in real time. And countering that is difficult. And I think you can't deny the actions or lack thereof that the defendant took. But I think what you can do is try to have the jury focus on the facts and try to argue that their emotions should not come into it. That my client, this defendant, he is not a stand-in for the shooter. I think the community, because I think one of the reasons, and I don't know if you agree with this, I think one of the reasons this is going to trial is that you don't have the shooter to hold accountable. Sure. And they're looking for someone to try, someone to place blame, someone to hold accountable.
Yeah, and that's a scapegoat argument that the defense will make. Like, this guy, and they started that in their opening statements. This is not the monster. This is not the
Yeah.
guy that pulled the trigger. And so their goal is to show what he did do. And he did do a number of things. But clearly the prosecution's position is, well, he didn't do enough because we got 19 dead kids. It is a brutal case. Let me ask you one more thing about this case because it was fascinating on day one. Have you ever seen a situation in which you have an alleged Brady violation? In this case, the prosecution had a witness, one of the teachers, who said on the stand for the first time in terms of the defense learning it, that she placed the shooter on the same side of the building as Adrian Gonzalez. And he was there at 11:21, so very much right at the beginning. So that's a huge issue if true, because it gives him notice and an opportunity to see the danger, evaluate it, figure out what to do, how to stop it. But if he wasn't there and didn't see this shooter, then it's a whole different dynamic. So she comes up with this information for the first time, as far as the defense is concerned. Little exploration. Turns out she told the prosecutor a month and a half ago, and they never shared that information with the defense. So classic scenario. Have you ever seen a situation where the defense said, and this was after her direct, let's go ahead and cross-examine her, and counsel kept saying, I want the chance to unring the bell.
Yeah, which
now
normally, go ahead.
Well, I'm just thinking, I think you're going to re-ring the bell every time you get into it. And then ultimately they did, the court told the jury to disregard her testimony. So the jury has to be totally confused. First of all, I'm not sure they think whatever she had to say was that important because they don't know yet. But in closings, the prosecution certainly would have pounded away on that. Now they aren't going to be able to because her testimony has been stricken. But this poor teacher gets kind of sandbagged because she spends her time and she's emotional. And now she's told by the court, thanks for nothing. Have you ever seen anything like that?
Obviously, I've not seen anything.
I would hope not, but I had to ask.
Yeah. That's what we're always arguing, right? As often defense attorneys about, we need a mistrial because you can't unring that bell. There's no instruction that you can give. There's no curative instruction that you can give to fix this, right? And we had that in YSL all the time. And that's actually what caused that long break where a lot of the defendants pled out, including Jeffrey Williams, is there was an issue. And we said a curative instruction cannot fix this. So no, I have not seen that before.
And I think sometimes the curative instruction reinforces it, right?
Yeah. And the judges will ask us.
Go ahead.
Yeah, I mean, during sidebars, and you've probably experienced this, during sidebars, the judge will often ask the party that's been wronged, let's say it's the defense attorney, that's usually who it is, do you want a curative instruction? And normally we say no, accompanied by, get this on the record, no curative instruction can fix this. Nothing absent a mistrial can fix this. If you say, yeah, I'll take a curative instruction, then you might screw up things on appeal, and those curative instructions don't fix anything.
No, I think they highlight something that you're trying to avoid, and you're right. It could be argued you waived any right to appeal because you've accepted that as a remedy, right?
Yeah.
And I have to think. I kept wondering. I wonder what really would have happened if this had been much further into the trial, not the third witness on day one, right? In terms of the harm and the impact of a Brady violation, which the court determined was not intentional, was negligent at best. And I have to play this for you because it's a clip that I pulled. It's almost as good as my Fonnie Willis Typical Man that I pulled from her hearing. This was Miss Mitchell, one of the prosecution attorneys, being questioned by the defense out of the presence of the jury about her investigation to find out when they learned this detail that they had not shared. And this is only 3 seconds, but this was one of her responses.
You're getting very nitpicky.
You're getting very nitpicky.
Very nitpicky.
So, these damn attorneys getting nitpicky. And so, she was on the hot seat. She looked horrible. The jury will never know any of that. And I have a feeling with the case that is supposed to be a few weeks long, this will be a distant memory. They will not even have a recollection of this teacher or the testimony they're supposed to forget. Thoughts?
Well, let's hope so. Yeah, let's hope that's the case. I don't know how long this trial is supposed to take. I'm afraid what they're going to take into the jury room are all these pictures that they saw today.
Of course, and they're going to say somebody needs to pay, and it's so hard. And this is again why I want to talk to you about the defense perspective here. So hard to get this jury to put themselves in Adrian Gonzalez's shoes on that day as a cop encountering this thing that was unfolding.
And that's an argument you can't even really make on closing because it's an inappropriate argument to make to the jury.
Say, what about you? What if it were you? That kind of argument? Yeah.
You can't make that. At least in Georgia, you can't make that argument.
That's a golden rule argument. Isn't that one of those golden rules they said that you can't violate? Yeah, I think there's case law on that.
That's one I think I could get sanctioned for if I tried to make that argument. But yeah, you can't make that argument. So I know the defense is in a tough position. I feel for them. Part of me remembers the old failed rescue doctrine from law school, which is, in tort law, you've got, as a bystander, you're not required to act, but this is a different situation. He's a law enforcement officer. He has to act. And I'm trying to remember that as I see the state's case. Because clearly this officer should have done something.
Yeah, and I'm still, following along to find out where those opportunities were when he should have known. To me, it's when did he know what was really happening, and what should he or could he have done at that time? I don't know yet. It's a little fuzzy as to when he learned the gravity of what was actually happening. I had a thought. Tell me about this. From a demonstrative standpoint, I know it will be objected to, but I'd give it a shot anyway. They had an expert on today. If I were the prosecution, I would try this. They had an expert on today that would talk about the trajectory of all the bullets because they were looking at the defects, where they had hit, where they, windows they went through, walls, ceilings they'd hit. And they used a, the old, dowel project, where they put a dowel through and to try and show the trajectory. He admitted that they could have used a laser to do that. My thought was to really reinforce what a barrage this was, and that's the word I'd be using until somebody stopped me. If you use a laser on all of those points at the same time, and had like this really intense, basically like a light show of what it was like. Now that is somewhat misleading. I could definitely use it for closing argument, but it might be misleading in that suggesting they were all happening at once. There was no gap in between them, but I think it would show the jury that that's how dangerous it was. That's the flight path of all of these bullets, that it was almost more likely than not one of these kids was going to get hit. And obviously 19 of them were killed. What do you think about that technique? Would you give that a try?
If I was the state, I would give it a try.
Yes.
It's
and you'd be jumping up and down if you were the defense.
I don't know, but it's misleading, right? Because it does imply it was happening at the same time. It would look like something off of the that early Tom Cruise Mission Impossible movie. Isn't that the one where there's all these lasers and he's trying to...
Okay, here's my backup plan then, Your Honor. Here's what I will do it, one light added over a period of time. Let's say all of the shots were, you okay with that? All the shots were fired over 15 minutes. So
I'm better at that.
Boom. You're better at that? Boom.
I'm better at that one.
Boom, boom, boom. So each one would reinforce the danger, which is, that's what they're supposed to be proving in this case.
Yeah, that case, Uvalde, I've not been following because it is such. I have a 10-year-old. I just can't follow that.
No, it's brutal, and I know a lot of folks in our audience as well. We were waffling, about it, and I felt this was my decision, that it was such an important issue and such an important, it kind of reminded me of the Ethan Crumley case in Michigan, where the parents were held as they were guilty of involuntary manslaughter because they didn't stop their kid from using the gun he did in that school shooting.
Given the circumstances of that case, I think I kind of agree with the state on that one. I hate to do that as an attorney, but when you hear all the facts behind that case, I totally understand that prosecution. Yeah,
I was kind of curious whether both mom and dad would be held because they did them in separate trials. I felt the mom was maybe more culpable, but they got them both. But I looked at this case, the Uvalde case, in kind of the same context. This is a failure to act. And you mentioned a good thing, and that's the Good Samaritan type laws, where regular folk, you can sit back and record it on your phone, right? But
you don't have
you got
that.
Yeah, you don't have that defense. You're paid to get in there and run toward the danger when everyone else is running away. So
Yeah.
well,
Exactly.
fascinating case. What do you got going on before I kick you loose here? What's the latest? What can we look for, and what are you working on?
I'm about to go to trial with Bruce Harvey in Clayton County, Georgia, just around the Atlanta airport area, a little south of the Atlanta airport. We've got a murder trial there that we're going to be conducting together, which I'm looking forward. I've been on several cases with Bruce over the past few months, and none of them have actually resulted in a trial. So I think this one will go to trial. So I'm looking forward to actually seeing Bruce in action. He actually just got through trying a case last month with Nicole Westmoreland, a 2 or 3 week trial. If you remember Nicole, she was on the YSL trial as well, and she was on the Diddy case.
That's right.
So they tried a case together, and now it's my turn. I hope to go with Bruce on a case.
All right, getting the band back together. You guys, there's
There you go.
a core of folks there. Well, good luck with that. And what can you tell us the nature of the case? What it's about?
It is our client is a middle school teacher who is accused of being a Crip and participating in or ordering the execution of 2 young children, or 2 relatively young children, to send a message for some issues that was happening within that gang. So it's a really horrific set of facts, and it's going to be a trying case for everyone involved to go through this trial.
Yeah, well, good luck with that. Keep us posted. When is that? What's the official trial date?
I believe it is like around the 23rd, 24th of January, somewhere in that range.
Okay.
It's coming up on this fast. Well, I think 2 weeks from Monday, more or less.
Wow. Okay,
So,
well, get back to work. Yeah, that's a tough one.
Thank you.
That's
It's always good to be here.
Hey, good to see you, Doug. Always a pleasure. Have a great
Good to see you.
weekend, and can I still say Happy New Year? It's the 9th. I think I can still say Happy New Year.
You can't. I'm going to go play some pinball when we get off the.
Cool. I see that in the background there. What game is that? What it is in the background?
This one is King Kong. So.
Oh, that's a good one. Yeah.
Take my mind off all the other stuff.
Okay, go get the high score.
All right.
Okay,
There you go.
take care, bud. Bye.
See you guys.
Good guy. Always fun to catch up and see what he's up to. Okay, I'm going to do something now that I forgot to do last night because I'm not good. That's all I can say. Let me pull this up. I got a couple of things that I let slide yesterday after I let Serena check out. And so now I've got to find them so I can read them to you. Hold on. Stand by. Here we go. First of all, Laura, I'm going to say it's Riker, new member, and then within a few minutes, she did a super chat and had a question. Actually, a discussion we were having, as you may recall, it relates again to the Uvalde case because we were talking about that with Serena last night. In my daughter's preschool, you had to scan your thumb to get in. Okay, and I had mentioned that my son, when he was in grade school, which is 15 years ago now, we had like a camera, and the doors were all locked electronically, and there was no coming and going, which we know has been an issue in this Uvalde case. Shaq, I'm like, Shaq, what? We went from you used your thumb to get into Shaq. Shaq's was so big, they had to get a special one for his huge thumb. Our kids were in the same class. Oh, you buried the lead there. They were in the same class. He is an extremely nice man. And Laura, I'm going to say, Riker, I may be wrong. You're a very nice person. Thank you for the donation. And we also had Music to My Soul. To Serena's point, it's wild that the same judge trusted the jury. We were just talking about this with Doug. Trusted the same jury to obey the exclusion and said they likely didn't notice the issue in the first place, which is one of my thoughts. And that first witness or third witness, first day, they're not sure what her testimony means. And by the time this case is over, they may never know. But it's been reinforced a few times that what she saw, you're not to give any thought to. It's always a difficult situation. But thanks to Music to My Soul for that super chat. Appreciate that. Jackie Zidell said, I like Ms. Townsend. My first time seeing and hearing her. And Barbara Cox said the same thing, that I really like Ms. Townsend. She's all right. Yeah, she's good. So let me see what else I got here before I... this is very nice. Peaches. Thank you, Peaches. 1982 became a YouTube member. We appreciate that. And of course, Donnie Knott Wahlberg, 1 Just to Serve TV membership. Thank you. And that maybe that's the one that went to Peaches. I don't know. And Kay Schmidt, 5 Just to Serve TV memberships. Thank you. You guys are always so supportive. We definitely appreciate that. And Madeira Beach caregiver, Dougie Fresh, watching the Trial Channel sidebars. Okay. Yeah, the Trial Channel, which was such a difficult name for me to remember that when we were using some of their footage, I couldn't remember. Trial Channel. They do a great job putting the stuff together. The sidebars, could be a mess, but what they've done, if you haven't had a chance to look at it, we're talking about the sidebars from Karen Reed 1. Some of them, at a certain point, I'm just like, I'm not surprised. I'm further aggravated. I got to let this go. But they've done a great job of taking the actual footage from court. And then when their sidebar is called, they have some actors who are doing, the voices of the sidebar. So let me, when they get to trial number 2, I'd like to Trial Channel. Could I audition for Hank Brennan? I'd like to be doing the Hank Brennan for the sidebars. If you can make that happen. So, and those things are going to keep trickling out. Apparently, the transcripts that were squirreled away and are now out there for everybody to enjoy. All right, that's going to do it. I guess the big news is that the lovely Linda Kenny Baden will be back on Monday. I may take Monday off. What the hell? And we'll be back in the Uvalde case, plus a couple other things that are going on that we will continue to update. We're going to try to get Mark Betterow on. He did his Sir reply, which we did as a members only on Wednesday. That will break out this weekend, where we go through the whole document, talking about Robert Cosgrove. As you'll recall, the June 23rd hearing, which is going to be in Boston, is specifically about the recusal of Special Prosecutor Robert Cosgrove in the Aiden Carney cases that remain, the 2 of them, because of conflict. And then at some point, hopefully, the mega motion to dismiss will actually be argued. We got to get through this first. So anyway, check that out over the weekend. That's about it. I got something else I was going to do over the weekend too. Oh, I have a little, legal edge thing. One of my passions is helping people in the real world, not the criminal world. And even when I was in law school, I was a special mentor for small claims. Yeah, what did I know? I wasn't really an attorney then, so they couldn't come after me. But I was helping folks with small claims, which is a fascinating process. And I want to talk to you about one that I did. I'm going to do that as a separate little show. And it's a nice how-to in the real world, how it works, how you can enforce your rights, how you can make others do the right thing. Generally, big business and big government is who I go after. And I've got an example of that. So I don't know if I'll do that this weekend or maybe sometime next week. But it's rattling around in my head. All right. Hey, have a great weekend. Glad you could join. See us again. See some stuff we sprinkle in over the weekend, but see us again on Monday. Linda Kenny Baden will be back. In the meantime, I am Michael Bryant. There's Domino. Has not moved a hair. This is Just to Serve TV. Please try to do the right thing.
It's on the sky.